Can undocumented immigrants get a green card in 2025? Can I get a green card if I'm undocumented? It's one of the most common and emotionally charged questions in immigration. If you're living in the United States without legal status, it might feel like the door to permanent residency is permanently locked. But here's the truth. It's not. It's just complicated. Whether you overstayed a visa, entered without inspection, or were brought here as a child, there are legal pathways that could help you get a green card in 2025. They're not easy. Some depend on family. Some depend on your history. And most require legal help, paperwork, and patience. But the good news is, it's possible. Let's break it all down. First, what is a green card? A green card means you are a lawful permanent resident. It gives you the right to live and work in the U.S. permanently. You can get a driver's license, apply for health coverage, sponsor certain family members, and eventually apply for citizenship. For undocumented immigrants, getting a green card means safety, freedom, and recognition. It changes everything. Let's talk about how. Marriage to a U.S. citizen or green card holder. This is the most common route. If you entered the U.S. legally, even if your visa expired, you may be able to apply for a green card from inside the country. That means filing Form I-130 and Form I-485. You'll need to prove the marriage is real and go to an interview. But if approved, you get your green card without leaving the U.S. But if you entered without inspection, crossed the border illegally, you usually can't adjust status from within the U.S. You may need a waiver and must leave the country for a consular interview. The waiver is critical. It forgives your unlawful presence so you can return legally. If your spouse is only a green card holder, not a citizen, you can still apply. But there may be a waiting period before a visa becomes available. Asylum and humanitarian options. Not everyone can marry or has family who can sponsor them. But there are other paths, especially for people who faced harm, danger, or abuse. You may qualify for asylum if you fear persecution in your home country based on race, religion, political opinion, nationality, or social group. If granted asylum, you can apply for a green card 1 year later. If you've been abused by a U.S. citizen or green card holder who is your spouse, parent, or child, you may be eligible under VAWA, the Violence Against Women Act. This lets you self-petition for a green card confidentially. If you're a victim of a crime and helped law enforcement, you may be eligible for a U visa. After 3 years, you can apply for a green card. There's also special immigrant juvenile status for undocumented children under 21 who were abused, abandoned, or neglected. And if you're from a country experiencing war or disaster, you may be eligible for temporary protected status. While TPS doesn't directly lead to a green card, it can sometimes open the door. Cancellation of removal in immigration court. If you're already in removal proceedings, you may be eligible for cancellation of removal. This stops your deportation and gives you a green card if you've lived in the U.S. for at least 10 years, have good moral character, and your removal would cause extreme hardship to a U.S. citizen or green card holding family member. It's hard to qualify and only granted in court, but when approved, it's life-changing. Programs that may help. DACA and parole in place. DACA doesn't provide a green card, but it gives protection and work authorization. And if a DACA recipient travels with advance parole and re-enters legally, they may become eligible for adjustment through marriage. Parole in place is for undocumented family members of U.S. military personnel. It gives a legal entry on paper, making green card applications from inside the U.S. possible. Advance parole and re-entry can also help DACA or TPS holders become eligible for adjustment. It's a rare opportunity, but a valuable one. Common obstacles. Even if you qualify, there are risks. If you've been undocumented for more than 180 days and leave the U.S., you could face a 3 or 10-year ban. That's why waivers like Form I-601A are so important. If you entered without inspection, you can't adjust status inside the U.S. unless you qualify for special programs. Past deportation orders, false claims to citizenship, and certain criminal convictions can block you from getting a green card. Always be honest in applications. Misrepresentation can lead to permanent bans. Legal tools that can help. Waivers like Form I-601 and I-601A can forgive unlawful presence and other bars. To get them, you must prove extreme hardship to a U.S. citizen or permanent resident spouse or parent. Whether you adjust inside the U.S. or go through consular processing depends on your case. And while some people file alone, working with an experienced immigration attorney can be the difference between success and denial. Stay informed. Immigration laws change. In 2025, Congress may act on immigration reform. Updates to DACA, TPS, and other humanitarian programs could create new paths or remove existing ones. Follow trusted legal sources, check SIJS updates, and be ready to act if new opportunities open. So, can undocumented immigrants get a green card? Yes. But it depends on your situation. Marriage, asylum, cancellation of removal, humanitarian programs, or waivers can all help. But the path is complex. It takes evidence, patience, and often legal help. If you or someone you know is undocumented and wants to adjust status, don't wait. Get informed. Get prepared. And talk to a legal expert. Because everyone deserves a chance to belong.